Looks like you guys lost the high school students. We are here in the matter of Trask versus Dr. Ahmed and others. And it looks like the parties are ready. Mr. Marty?
Thank you, Your Honor. Does the court still want my high school and hometown? I'm happy to.
City.
I'm an Iowan by marriage, Helena High School, Helena, Montana. Go Bengals. Chief Justice Christensen, members of the court, counsel. We're asking that this court reverse the district court for errors at law in determining that Trask 2, this case, was not a continuation of Trask 1 under Iowa Code 61410, the saving statute. I want to start by making it clear what we're not asking this court to do. We're not asking this court to revisit Iowa Code section 147-140, the savings or the certificate of merit statute. We're not asking this court to revisit any of its decisions regarding that statute, such as Miller versus Catholic Health Initiatives, Van Wert versus Neurosurgery of North Iowa. Instead, we're asking that this court determine that the saving statute, 61410, applies under the circumstances so that Trask 2, this case, is a continuation of Trask 1 for statute of limitations purposes. Iowa Code 61410 provides that in certain circumstances, an action that fails, and fails not due to negligence in the prosecution, can be refiled within 6 months, and the refiled case is deemed a continuation of the earlier case, and that's important in circumstances like this, where the statute of limitations runs in the interim. The saving statute reads specifically, if after the commencement of an action, the plaintiff for any cause except negligence in its prosecution fails therein and a new one is brought within 6 months thereafter, the second shall, for the purposes herein contemplated, be held a continuation of the first. So we're asking that this court find that the saving statute applied and reverse the district court for errors at law in finding otherwise. There's two requirements that are at issue here. There's a number of other requirements in the saving statute that aren't at issue at here. I think that's conceded. The two factors at issue here are, one, did the earlier case fail? And two, did it fail because of negligence in its prosecution? So taking failure first, Trask 1 indeed failed. It's important, I think, to talk about the procedural history of Trask 1. Trask 1 was filed in September of 2023. It's a medical negligence action.
At that point, what's in our record as to Trask 1 that we can look at?
And I think this is an issue raised by the Appellees regarding judicial notice of earlier or other court records. This court has held in, well, the general rule cited by the Appellees regarding judicial notice of prior proceedings is that the court doesn't take judicial notice of those. There's an exception, though, in re-interest of Adkins. The court can take judicial notice of prior proceedings when the actions are not separate and distinct actions, but interdependent and interwoven. So I believe that when it comes to the saving statute, where we're asking this court to find that Trask 2 is literally a continuation of Trask 1, that those actions are indeed interwoven and interdependent. And in fact, the court finds the saving statute applies, they're the same action.
I am Mr. Marty. Your petition in Trask 2 talks about, it describes various events that happened in Trask 1, including certain things that were filed, certificate of merit, the motion to dismiss, summary judgment, whatever it was. And we have a rule sometimes that where the petition talks about a document, then you are allowed to rely on that document in resisting a motion to dismiss the petition. The problem I have, if it may be, is that I still don't have in this particular file copies of the things that were actually filed in Trask 1. Maybe that's a problem, or is it?
They should have been part of the appendix, and I guess to the extent we can, we'd ask to be able to supplement the appendix with those. But the Appellees here likewise argue the procedural history of Trask 1. They seem to agree, and the parties seem to agree on exactly what happened in Trask 1 in terms of when it was filed, when certificates of merit were produced, what the certificates of merit say and what they don't include, the motion for summary judgment in Trask 1 and the district court's ruling. So I don't think there's a disagreement among counsel and among the parties as to what procedurally happened in Trask 1. So talking about then what happened in Trask 1, filed in September of 2023, certificates of merit exchanged and produced in November of 2023. The case was litigated for a period of time, and then in May of 2024, this court issued its ruling in Miller versus Catholic Health Initiatives, in which it said certificates of merit in a medical negligence action have to include either under penalty of perjury language or be sworn in order to substantially comply with 147, 140. Trask certificates of merit did not include the under penalty of perjury language. They were not sworn. They did include an affirmation, but it was clear at that point that under Miller, Trask certificates of merit were not substantially compliant. And so the defense, the Appellees, moved for summary judgment. That motion was certain to be granted under Miller. And so Trask took the only option available to him at that point, which was dismissing Trask 1 voluntarily and refiling under the saving statute. I'm sorry.
Our cases on what constitutes failure, it seems like most, if not all of them, involve procedural issues. There's some sort of procedural thing that happens, and then the case has to be voluntarily dismissed, and you start over. This seems a little bit different to me in the sense that the certificate of merit affidavit is kind of quasi-procedural, quasi-substantive, and it seems odd. I'm not saying that the case law wouldn't go there, but I'm trying to wrap my head around this, that you're going to lose the case on the merits, and the way to avoid that is to voluntarily dismiss the case and then start over again. I'm having trouble kind of doctrinally, conceptually fitting those old cases into this statute.
Your Honor, I think you're right that most of the cases talk about procedural failures, a failure of subject matter jurisdiction or venue, correct, due to the dismissal of a defendant, something like that. So that's a common situation for this issue to arise. But first, the statute itself doesn't say failed for a procedural reason. The legislature could have wrote that into the statute, but it just said fails. It doesn't say it fails procedurally. There's a court from the Northern District, Doe versus Hartz, that involved a federal claim under the Violence Against Women Act and related state law claims. The court ultimately dismissed the Violence Against Women Act and claim, then depriving the court of subject matter jurisdiction. The claim was refiled and the saving statute applied. So it does apply when claims fail substantively as well. And here, Trask's claim failed, like Your Honor said, quasi-procedurally. And I guess the question is the voluntary dismissal of Trask 1 a failure for saving statute purposes? And under Fernald v. Hughes, it is. Fernald involved completely different facts. A plaintiff who dismissed his case shortly before trial in order to buy himself more time to develop medical expert evidence. He notably didn't seek a continuance of the case in order to do that. He just voluntarily dismissed. This court said that that was not compelled under the circumstances, and it made compulsion sort of the hallmark of how we decide whether a voluntary dismissal is a failure of a case for saving statute purposes. Contrast.
In your argument on compulsion, could you address Chief Judge Lars Anderson's finding or his legal conclusion that it was negligent not to have a proper compliant certificate of merit in Trask 1?
and I think that his analysis comes from the Fernald case, which seems to blend failure and negligence concepts. Judge Anderson said, yes, it was negligence in the prosecution not to have what we know after Miller were non-compliant certificates of merit. That's one of the issues we obviously disagree with the district court on and why we're here. But separating out the negligence aspect, Trask didn't have any viable alternate options to litigate his case. Once Miller was decided and a motion for summary judgment was filed, dismissal was a foregone conclusion. And under 147-140, dismissal is required and mandated with prejudice. The Appellees suggest that to constitute a failure, Trask was required to get to the point of having a final decision on his case. The catch there is that would have resulted in dismissal with prejudice, and once there's a final decision on the merits, the saving statute can't be applied anymore.
For Nald, the negligence in this context is not the negligence in creating the problem that leads to the potential dispositive motion. It's the failure to take available options after the problem's been presented, which seems like what you're saying is you didn't have any because there was no basis to resist, which maybe that's right. I don't know. But is that your understanding of Fernald too? It's about kind of the options available afterward. And then the follow-up question is, can you address footnote 5 of Miller and how we should think about that in this context?
Fernald first. Again, Fernald blends the negligence concept, and if Your Honor's question is the way we look at Fernald and the way we look at failure and negligence under the saving statute, I think we can stop the analysis here and reverse the district court because there were no available options to Trask, and so there was no negligence in failing to press a totally, entirely futile option of resisting the summary judgment motion, which would have resulted invariably in the dismissal with prejudice. I'm not arguing that that's where we should stop, but if we look at it that way, we can. And I believe, I apologize, I don't have footnote 5 of Miller committed to memory. Is that where the plaintiff is allowed to dismiss and refile his case?
So what bearing does that have here, if anything?
Has one, because at the point of the summary judgment motion in this case, the statute of limitations had expired. And so simply dismissing and refiling wasn't a viable option. So on negligence, assuming that what Fernald meant when it talked about negligence was not just limited to failing to pursue available procedural options, this court has talked about reasonableness as being the benchmark of negligence and focuses on what the litigants, whether the litigant's conduct was reasonable before the failure of the first case. The Appellees take issue with this reasonableness concept, but it's discussed in a number of cases: Wilson v. Wright, Sauter v. Interstate Power. The dissent in Boomhauer versus Sarah-Godero focuses on reasonableness, and reasonableness is a synonym for not negligent. Those are related concepts. In fact, the definition of negligence is acting reasonably under the circumstances. So the question comes, was Trask litigation conduct before Miller was decided with respect to certificates of merit reasonable? And it certainly was. The best evidence I think we have for that is the dissent in Banmort, in which two members of this court signed on to an opinion that would have held that a certificate of merit that included an affirmation materially identical to Trask's certificate of merit or certificates of merit would have substantially complied with 147-140 because an affirmation is under penalty of perjury, binds the affiant's conscience to his or her statements, and thus accomplishes the essential objectives of the statute.
Argument in favor of reasonableness that the defense lawyers weren't, pre-Miller, were not typically moving to challenge an unsworn or a non-compliant certificate of merit. It wasn't until after Miller, they were sometimes years into the litigation that began to happen.
Evidence. I don't think it's dispositive, to be fair to my colleagues on the other side. I think in Banmore, this case said waiver is not on the table, and the defense controls the timing of their motion. But I think it's certainly evidence of reasonableness. And a good example of that is the SK case that this court considered in 2022, which they attempted to raise the certificate of merit issue post-trial and on appeal. And that case was a massive verdict for the plaintiff, and I think it's evidence, yes. And I'm out of time.
In a little bit. Thank you.
I'll just close the loop. I'm a Des Moines North Polar Bear. I don't want Justice McDonald and Mr. Apple to claim the field on Des Moines Public Schools.
Like here.
I'm from Humboldt, Table Rock, Steiner, go Titans. It's a Nebraska school, so don't hold that against me.
May it please the court, counsel. Your Honors, let's be clear about what Mr. Trask and his counsel are asking this court to do. They're asking the court to stray from well over a century of its own precedent regarding Iowa's savings statute and the application of that statute, section 614.10. Mr. Trask requests a ruling that even where a plaintiff has procedural options available to them in the underlying litigation, they can still voluntarily dismiss and seek refuge of Iowa's savings statute.
If Trask had gone that route, you would have immediately said those options are not options. You would have filed and countered those. I mean, really? Right?
Clearly, we believed that the motion for summary judgment was meritorious. However, what we see in this court's line of cases, and I'm thinking of that earlier line, Archer and Kepperly and Party, but I think Fernald applies. Futility does not, a strategic judgment about futility does not equal failure.
About Weiss. In Weiss, there wasn't any motion. In Weiss, I think he called the judge, and the judge said he wouldn't move trial, and then he called opposing counsel, and opposing counsel said he wouldn't agree to it, and he called the judge back and said, I'm dismissing. So there wasn't any filing there, and we found the savings statute applied.
I think the way I read Weiss, Justice McDermott, is that the court, in that case, this court, sort of liberally construed the request by the lawyer for a continuance. So while he didn't file a written motion to continue and there wasn't a written ruling denying it, he did invoke that option to continue the case. Whereas in the prior cases involving continuances, none was ever requested. Voluntary dismissal was just entered. So I think, given the circumstances there, that this court gave a liberal construction and said, that's a request for a continuance. You tried that option. Now you're out of options. And then I think the compulsion aspect is very strong there. I mean, the facts of Weiss are pretty extreme. Get to trial the next day, you're 250 miles away, and your client lives 150 miles from there. Once your continuance is denied, you're out of procedural options. The other problem, just to get back to Justice Mansfield's question, that I see with this idea of futility is certainly all of the plaintiffs in these prior cases, in Archer, in Kepperly, in Fernald, would have said, well, if I proceeded, I was likely to lose. And exactly what are we asking district courts to do in evaluating the perceived futility idea from plaintiff's counsel?
Wasn't likely, right? I mean, we know that he was gonna lose. In those cases, we didn't know. At least I don't read them as saying that. But here, I mean, all of our cases since then have said he was gonna lose.
Entirely clear, Justice McDermott. There's a couple things I would say. One, as the court is well aware, many plaintiffs throughout the state used their procedural options and litigated motions for summary judgment, depending on certain facts of those cases, raising multiple arguments. Now, the court has found, sorry, Justice Mansfield.
What I hear you saying is almost that the statute should only apply if the judge involuntarily dismisses without prejudice. But we have applied the statute in some situations of a voluntary dismissal without prejudice, right?
I'm not contending that it has to be an involuntary dismissal. I think
once you allow it in some voluntary dismissals without prejudice, then you are kind of evaluating, you know, how tight a pickle was the plaintiff in, and based on these cases, it seems like the plaintiff was in a pretty tight spot, right?
agree, Your Honor, is that the prior case law is a little bit mixed about exactly what the criteria are that we're evaluating. And I think in Fernald, this court noted the prior cases tended to combine failure and negligence. It seems that the statute is a little bit more mechanical than really this sort of reasonableness evaluation. If the dismissal is something that's as the result of a technical pleading minor mistake, and you've exhausted your procedural options, then you might be able to seek refuge under the statute. When we talk about those prior cases, the option that was available was to resist the motion for summary judgment. Now, so far, this court has affirmed or reversed in the case of denials of summary judgment the dismissals on that, on 147, 140. But I would note, there are still pending appeals in front of this court on that issue, and in this case, Trask pled failure of informed consent, which the case, I know that is pending in front of the court in Lofgren. So that was their option. And to claim refuge of the saving statute, you cannot forego your options and say, I think I have a better chance. What we know failure can't be is a strategic choice. That's what Fernald said. Because clearly what happened in Fernald was the lawyer made a strategic choice to pursue additional evidence, develop their case further. And we know that can't be the case. Here, rather than pursue their option of resisting the motion for summary judgment on whatever grounds that might be, they chose to voluntarily dismiss.
If they would have resisted under our case law as it exists, the motion for summary judgment should have been granted. So the options are you have to proceed to dispositive motion and have a judgment dismissing the case with prejudice, or, I mean, I guess I don't see why that's a viable option. That just seems very different than all of the cases, at least that I've read, that involve procedural issues where the consequence was, well, you'd be forced to go to trial against your will, but at least you'd have a trial on the merits. I mean, it seems like you're saying they were required to lose with prejudice, and then when they refiled, it's res judicata, so they should just lose, period.
So I would address that in two ways, Justice McDonald. First of all, what we know is that, and you talked about this with my opposing counsel here, generally, we have situations where there are dismissals without prejudice, and that's a procedural issue. That's when the court has found the saving statute applies. Here, they were facing a dismissal with prejudice, which does make it unique. But that's where the aspect of negligence in the prosecution comes into play. Because the court has to ask itself, if counsel or plaintiff has put the case in a position where they face a dismissal with prejudice, not due to an arcane or a procedural issue like jurisdiction or venue, can it really be said that they pursued the underlying action, or that the failure of their underlying action was not due to the negligence of the plaintiff?
What we do with the district court's statement that it was negligent not to have a compliant certificate of merit originally, but this is on a motion to dismiss, and if the petition alleges, in effect, or we can infer that the petition alleges it was reasonable at that time to use the form of certificate that they did, shouldn't this case proceed? And do we need a trial? Is it a question for the trier of fact to decide whether it was negligent or not regarding the type of certificate they had back then that other people were using?
Baked into that question, Justice Waterman, what I would say about the negligence in the prosecution issue is we've raised the pleading aspect of this. And we take issue with the fact that there's both things that aren't pled in the petition, and then there is information regarding discovery that's injected into the record. Given what was pled, and given the state of the case law, I think Judge Anderson had ample basis to decide as a matter of law in a motion to dismiss that the failure to comply with Miller, the failure to comply with 147-140 under Miller and its progeny was not reasonable and was negligence in the prosecution.
What do we do with Wilson versus Wright? Because in that case, it seems to me that we found that the lawyer misread a new statute, and we found that the safety clause applied.
I agree that Wilson versus Wright.
Say the person was led into the courthouse after hours on a Friday night somehow and filed something that didn't get filed until Monday. But in that case, it was a kind of mistake of reading a statute. And that's, I think, kind of what the argument is here, too.
So I agree with you, Justice McDermott, that the Wilson versus Wright is the hardest one to really make sense out of. And I think it's a great example of bad facts make bad law. And to your point, it was so bizarre, but it did fit within the purpose of the saving statute in the sense that this pleading standard was something that is sort of arcane and esoteric. You know, was the original notice filed on the same day as the petition? That's distinct from Section 147-140 in important ways. Under the Iowa Rules of Civil Procedure, dismissals with prejudice, and unless it's specified as not, like venue or subject matter jurisdiction, are considered adjudications on the merits. So in this instance, which is distinct from Wilson, be right, a dismissal subject to 147-140 is an adjudication on the merits.
Here doesn't make that distinction between merits or not. It just says fails.
Right.
So why should we read that in?
I don't think we have to read it into the statute. I think when you look back at the court's prior precedent, it has almost entirely, I think exclusively been in instances where the dismissal or the failure was without prejudice and for an issue not on the merits. And that's the situation, as in Fernald, when this court said the saving statute is sharp and narrow, not broad and blunt. And the sharp and narrow situation where it applies is if you have a dismissal without prejudice, either voluntary dismissal or a court dismissal, or some other failure that is not on the merits and not due to the negligence in the prosecution of the action. Now, we also know that the saving statute goes even beyond that, because if we look at the Souter case, even where you have a dismissal, in that case it was lack of diversity, even where you have a dismissal where the basis was procedural, lack of diversity jurisdiction in federal court, the saving statute did not save that action because of the negligence in failing to properly investigate and ensure that you did have diverse parties. I think that's very similar to this instance here. What this court said in Miller was that the failure to apply or the failure to comply with 147-140 is not a mere technical issue. And in Banwart clarified, Miller didn't change the law. The law was what it was that you had to have an affidavit prior to Miller. And that's not difficult to comply with. Many plaintiffs around the state did it. I respect our opposing counsel very much, but affidavit means affidavit, and under Iowa law, there's at least two ways to do it. Oath or Section 622.10. So it's not an arcane pleading standard that puts you at risk of a dismissal without prejudice. It's a substantive requirement in these types of cases. I'd just like to address,
Out like on a 66811 issue. I'm still struggling applying this to merits-based decisions, and maybe it doesn't make sense here, but
in the 668 context, there is some case law in that area too regarding voluntary dismissal. And it gets a little tricky because it really depends, on the particular facts of the case. But I do think there are scenarios there where, how did you fail with 66811 would be the issue. And so, if your expert dies before trial unexpectedly and they can't testify, that's probably not negligence in the prosecution. If you fail to get experts and they were required under 66811, that probably is. And that's sort of the way I view the distinction. I would just address quickly the question regarding footnote 5 in Miller, because I think we agree. What that footnote said was you can timely refile. This discussion of an absolute right to voluntary dismissal from Ronfeld does not mean that you have an absolute right to a voluntary dismissal and you have an absolute right to protection from the savings statute. That's not what Iowa law has been for more than a century, and I don't think the court should vary from it here. That's why you should affirm the district court. Thank you.
My friend is right. You don't have an absolute right to seek refuge under the savings statute. The qualifications are written in the statute. Did the prior action fail, and did it fail as a result of negligence in the prosecution? I think his discussion of 66811 and the did you not get an expert versus did your expert die in trying to harmonize 66811 to the savings statute would obviously implicate the negligence in the prosecution prong of the savings statute. Counsel's right. Miller didn't change the law on 147-140, but what it did do was find for the first time or discuss for the first time what's required to substantially comply with 147-140. And substantial compliance is written into the statute. When we're talking about reasonableness and whether Trask's litigation efforts in Trask 1 with respect to the certificates of merit were reasonable, we're looking at his conduct exclusively in a pre-Miller environment. All of that happened in 2023 without the benefit of Miller.
Can I ask you a question about a fact pattern? So in your case, if you would have resisted summary judgment, I think you would agree, I think you've argued, the district court should have granted it under Miller and Banwart, correct? And so to avoid that, you voluntarily dismiss and refile under the savings statute. So imagine a case where you have another 147-140 motion to dismiss, but it was filed too late, let's say after the dispositive motion deadline. And the party could have resisted the motion on that basis, and they didn't. And then they did what your client did here and dismissed the case and refiled. If you're right, the way those two cases would play out is your case that should have been dismissed on the merits gets refiled and gets to proceed, and the other case that should have been allowed to proceed because the dispositive motion is too late would fail under the savings statute, right?
That's interesting. When we look at Fernald and its discussion of...
You're wrong. That just strikes me as a very odd outcome if you apply our case law to those two fact patterns.
I would agree with you, Your Honor, that it's an odd and sort of maybe inconsistent result. And of course, that's a fact pattern the court can take up when and if it arises. But the question of failure and whether the dismissal was compelled under the circumstances, I think contemplates, are there other procedural options that could be taken? Here, we did not have any other procedural options that could have been taken. And dismissal was a foregone conclusion under 147, 140. So without those other procedural options, counsel characterizes the voluntary dismissal as strategic, but it certainly wasn't strategic in that the better of a number of options was selected. There was one option, which was voluntary dismissal. That's compulsion under Fernald, and that's failure under Fernald.
Would you mind responding to opposing counsel's point that we have had other cases where folks marched forward and brought a variety of arguments as to why they might be able to survive, notwithstanding Miller and Banwart?
First, I'll note that I'm not aware of a single one of those cases that's been successful. And in light of Miller and Banwart, I'm not sure any will be. And that's why I'm pretty confident in saying dismissal of Trask 1 was a foregone conclusion, because Banwart dispensed with, well, Miller decided that to substantially comply with the statute, you either need a jurat or under penalty of perjury language. Banwart dispensed with basically the rest of the arguments, void for vagueness, waiver, and any argument that Trask would have had has already been foreclosed by this court in Miller and Banwart. On the merits versus the non-merits discussion, I think my colleague was trying to convince this court that there's a difference between a merits determination and a non-merits determination for purposes of the saving statute. Again, the legislature could have wrote that into the saving statute and said a case that fails for a procedural reason is subject to the saving statute, while a case that fails on the merits is not. It didn't do that. And again, I'll point the court to the Northern District case of Doe versus Hartz. In that case, the federal claim giving jurisdiction in the federal courts failed on the merits. The case was then refiled under the saving statute, and the federal court, again, one of the parties moved during the refiling, and the court then had diversity jurisdiction. The federal court said that the saving statute did apply, even though there was a merits determination on the first case on the federal claim. The court also said, interestingly, on the negligence component of the inquiry, the adequacy of Doe's assertion of federal question jurisdiction in the first action, and I apologize, I'm over my time. May I continue my thought? The adequacy of Doe's assertion of federal question jurisdiction in the first action turned on close questions of statutory interpretation, or at a minimum on a complex interaction of law and fact. And then the fact that Doe's assertion of the federal claim was later shown in the course of litigation to be incorrect does not without more amount to negligence in the prosecution of her claim. So too with Trask.
Anyone else have questions? Okay, thank you, sir. The case of Trask versus Dr. Ahmed and others is hereby submitted, and court is adjourned for the morning.